Welcome to bongosikha aspirants. Today I am going to discuss the State Council of Ministers. So, as the Constitution of India envisages the model of the parliamentary system of government at the center, likewise the union pattern also as in the states, the chief executive authority or the real executive authority is the chief minister, the real politico-administrative system of the state, and the Council of Ministers is constituted and function in the same manner, likewise the Council of Ministers at the center. And there is no stipulated provision of the Constitution regarding the Council of Ministers. Only two articles, 163 and 164, deal with them in a broad, sketchy, general manner. That Article 163 deals with the status of the Council of Ministers, while Article 164 deals with the appointment, tenure, responsibility, qualifications, salaries, allowances of the Council of Ministers. Now, the constitutional provisions. These are very important constitutional provisions. That is Article 163, Council of Ministers, Article 163. So, there is a Council of Ministers with the Chief Minister as its head to aid and advise the governor so that he can constitutionally discharge his duties. But if any question comes regarding that whether any topic falls within the domain of the governor, then the decision of the governor is final. And one more thing, that the validity of such act, what has been done by the governor, cannot be judged or cannot be questioned on any ground. And the advice tendered by the Council of Ministers to the governor shall not be inquired in any court. So these three are the constitutional provisions, 163, Council of Ministers to regarding the governor. Next, Article 164, that chief minister is appointed by the governor and the other ministers are appointed by the governor on the recommendation of the chief minister. So it represents that the governor can appoint only those members as the ministers who are recommended by the chief minister. The total number of ministers, including the chief minister, shall not exceed 15% of the total strength of the legislative assembly. But here it should be remembered that the total number of the Council of Ministers, including the Chief Minister, shall not be less than 12 of a state legislature. So this provision was added by the 91st Amendment Act of 2003. So next, that either a member of the either house of the state legislature belonging to any party is disqualified on the ground of the defection. So this is another point. The ministers hold their office during the pleasure of the governor. The Council of Ministers, as I told several times, the Council of Ministers are collectively responsible to the state, to the Legislative Assembly for all their acts of omission and commission, and the governor shall administer the oath of office to the Council of Ministers. The minister who is not a member of the either house of the state legislature, such a person can be a minister but for a maximum period of 6 months. After that he has to be a member of either house, otherwise he ceases to be a minister. Then the salaries and allowances of the minister shall be determined by the state legislature in accordance with the time. So next, Article 166, that conduct of the business of the government of a state. So all the executive actions of the government, as I told in the first, that all executive actions of the government are always taken, are formally taken in the name of the governor. That executive actions means the appointment of all important officials, like the members of the Union Public Service, State Public Service Commission, the Advocate General of the state, the State Election Commissioner, that is the executive actions. So all the executive actions of the government of a state to be taken in the name of the governor. and the governor can make rules for the smooth functioning, for the convenient transactions of the functioning of the government of the state. So this is Article 166. Next I am going to discuss Article 167, that is the duties of the chief minister. It shall be the duty of the chief minister to communicate to the governor all the decisions and the actions has been taken by the council of ministers regarding the administration of the state and the proposals for legislation, and to furnish such information as the governor may call for regarding the administration of the affairs of the state and the proposals for legislation. So this is the Article 166. Next 177, that every minister who is a member of any house has the right to speak and take part in the proceedings of the any proceedings of the house of which he is a member, but he has no right to vote. He is not entitled to vote. That is the main thing. So next, the nature of the advice by the ministers. That is the Article 163 provides that there shall be a council of ministers with the chief minister, as it said, to aid and advise the governor so that he can constitutionally discharge his functions. But if any question arises which there is a dilemma that which that matter will fall within the domain of the governor or not, in that case the decision of the governor is the final, and any validity regarding the act has been done by the governor cannot be questioned to any extent. So that is the main thing. So nature of the advice. Next, the appointment of the ministers. The chief minister is appointed by the governor. The other ministers are appointed by the governor on the recommendation of the chief minister, which means that the governor can appoint those members as the ministers, those who are recommended by the chief minister. So usually the members from the either legislative assembly or the legislative council are appointed as the ministers. But if a person who is not a member of the either house of the state legislature, he can also be a minister, but within a maximum period of 6 months, he has to be a member of either legislative assembly or legislative council, either by election or by nomination, otherwise this is to be a minister. And a minister who is a member of the house has the right to take part in the proceedings of the house, but he is not entitled to vote. So this is the appointment of the ministers. Next, that oath and salary of the ministers. Again, that a minister swears that to bear true faith and allegiance to the Constitution of India, to uphold the sovereignty, unity, integrity of the India, to service to the people without any fear and favor, so to faithfully and constitutionally discharge the duties of his office. So these are the oaths. Next, collective responsibility, the responsibility of the ministers, collective responsibility. So this is the underlying principle of the parliamentary system, and in my earlier class also I told that this is the bedrock principle of the parliamentary system of the government. That is the collective responsibility of the council of ministers. The council of ministers as a whole, they are responsible to the state legislature for all their acts of omission and commission. They act together, they swim together, they sink together. So this is the main thing. So when the state legislative assembly passes no confidence motion against any member, the whole ministry has to resign, because this is the collective responsibility. And similarly, the legislative assembly can also influence the governor to dissolve the state legislature if it fails to reflect the will of the electorate and calls for a fresh election. So this is the principle of the collective responsibility ultimately which is meant, that is to support the cabinet decision, to stand by the cabinet decision inside and outside, the state legislature. That is the bedrock principle of the collective responsibility. Next, individual responsibility. That is Article 164 contents that all the ministers are appointed by the governor, and they enjoys their office during the pleasure of the governor. But the governor can dismiss any minister even when the whole council of ministers enjoys the confidence from the legislative assembly. So the governor cannot do this. He can do only with the recommendation of the chief minister. So the chief minister may request the particular minister if he is a poor performer or on the ground of the disagreement with the cabinet decision that to resign, or he may influence the governor to dismiss that particular minister. Thus the chief minister or the prime minister at the central level proves that by this individual responsibility they actually fulfills the principle of the collective responsibility, so which is very important. Next, the composition of the Council of Ministers. Likewise, the center here is also in the states. The Council of Ministers contains of the three categories, that is the cabinet ministers, the ministers of the state, and the deputy ministers. And the difference between them varies from their importance, their portfolios, their emoluments, their political importance, like that only. And the cabinet ministers always hold a very important role. They hold important portfolios like agriculture, education, banking, finance, etc. So this is the cabinet. Now I am going to discuss that the cabinet ministry. Earlier also I discussed that the kitchen cabinet or the smaller cabinet. So within the Council of Ministers there is a small body which is called the cabinet. The cabinet is the most ministers of the cabinet ministers are the most trusted colleagues of the chief ministers, and they influence the chief minister in taking all important decisions. So they play a very important role in the formulation of the governmental activities. So it is the role of the cabinet is the highest decision making authority of the state government. It is the chief policy making organ of the state government. It is the supreme executive body of the state government. It manages all types of emergency exigencies. It is an advisory board to the governor. It deals with all legislative and all financial crisis, financial matters. So these are the functions of the cabinet. And apart from this cabinet, there is a cabinet committee. And so the cabinet committees, these are of two types. One is the standing and the other one is the ad hoc. So standing is the permanent committee, and ad hoc are the temporary basis which are constituted on the basis of the exigencies, on the needs of the requirement, like that only. So this is all about the State Council of Ministers. I hope you all have understood all the topics I have discussed today. Thank you all.